Good morning, I'm Lisa Speaker. Today is September 11th and it is the 11th day of 30 days of appellate tips from the Speaker Law Firm. Today we're going to talk about how transcripts get to the Court of Appeals. So whenever a transcript is ordered for an appeal, the court reporter files the completed transcript at the trial court. The court reporter previously has sent some documents to the Court of Appeals called a stenographer certificate and a notice of filing. Those are just single pieces of paper letting the Court of Appeals know that the appellant has ordered the transcript, and then later knowing the Court of Appeals know that the transcript has been filed. But the court reporter only files the transcript in the trial court. To get it to the Court of Appeals, there are two different ways of that happening. First, if there's an appeal by right, after all the briefing is done, the Court of Appeals will ask the trial court to send the trial court record to the appellate court. And part of that trial court record are the pleadings that were filed in the trial court plus the transcripts. So the transcripts eventually get to the Court of Appeals with an appeal by right. If, however, you have an application for leave to appeal, then it is very important to know that the Court of Appeals does not get the record, and the only parts of the record the Court of Appeals has are those items that the appellant or appellee has supplied to the Court of Appeals. So if the transcripts are needed, and usually they are, if the transcripts are needed for the application, the appellant needs to file those transcripts directly with the Court of Appeals as soon as they're done. And sometimes that's not possible to do until after the application's been filed. But in any event, the appellant needs to make sure the Court of Appeals has the transcripts so they can do their proper review of the case.